This indictment states that on or about July 16th, 2025 in Jefferson County, Texas, which was the same date as the prior
Yes, sir.
event. In Jefferson County, Texas, you committed the state jail felony of abandoning. It's the statute is abandoning or endangering a child, but in the charging instrument, this says you acted with intentional, knowing, recklessly, or with criminal negligence, placed a child in danger by operating a motor vehicle while intoxicating. 25 CR 1215 is now called the State of Texas versus Jalen Nicole Brown. That's you?
Yes, sir.
Present with Ms. Manalva, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about July 16th, 2025, in Jefferson County, Texas, you committed the state jail felony of operating a motor vehicle in a public place while intoxicated with a child passenger, a child under 15 years of age. This is a state jail felony.
Judge, I believe there's a reindictment, and she's pleading to the reindictment, not this case specifically.
It is right as on the whole. So the DWI indictment will be a dismissal with a plea to the new indictment for endangerment of a child.
So we've got two different cases here.
That's correct. They'll both be disposed of today.
I just have the file yet.
You don't have a file on this? Okay.
No, it's
So-
The reindictment.
Reindicted last week, Judge. I don't have the new file yet.
Okay, then let's jump to 26 CR 1173. And the defendant waives a formal reading of this,
Yes, Judge.
and we proceed in summary.
Yes, Judge.
This was handed up on June 17th.
Last week, Judge.
Okay. Does the defendant waive any additional time that she may have under the law to proceed in this case?
Yes, Judge.
Okay, have you discussed this with your attorney, Ms.
Yes.
Brown?
Yes.
All right. And this is what you wish to do, is waive any additional time under the law that you may have. Since this was filed recently, you do have a little bit of time that you can prepare, but do you feel like you are ready to move forward and
Yes.
you've discussed this with your attorney and that is what you want to do?
Yes, sir.
All right. In 26 CR 1173, in summary,
Yes, Judge.
this indictment states that on or about July 16th, 2025 in Jefferson County, Texas, which was the same date as the prior
Yes, sir.
event. In Jefferson County, Texas, you committed the state jail felony of abandoning. It's the statute is abandoning or endangering a child, but in the charging instrument, this says you acted with intentional, knowing, recklessly, or with criminal negligence, placed a child in danger by operating a motor vehicle while intoxicated and to secure the child in a seat belt. And you did not voluntarily deliver the child to a designated emergency info provider. So was there an accident?
No, Judge.
Why is this? And the defendant did not voluntarily deliver the child to a designated emergency infant care provider under section 262.302. What's that all about? Why would that be? Reckless and engaging conduct by operating a motor vehicle while intoxicated and failing to secure the child in a seatbelt and did not voluntarily deliver the child to a designated emergency infant care provider. What happened on that? What's that all about?
But she was just pulled over in an accident.
Huh?
There wasn't an accident. She was just pulled over. Unless my memory
Well,
is
I mean, is that a
mistaken.
necessary element of the offense, though, that's been alleged or not? I mean, I don't get these a lot, if ever. This says section 22.041F, offense code 3899. I mean, there's no referral or in the indictment to what code that is referring to. I don't think it's the penal code. Yeah. But it is. Yeah.
Yeah.
I feel like it's already alleged in
They brought her back in.
just ending with place.
Okay. And she took her boots down.
And imminent danger of death voluntary. That's an actual statute.
Yeah, I believe. She never question what they. I'm still learning, but yeah, go ahead. I'm only.
But I think that we can
Once you borrow
probably
back-
just abandon that sentence.
I don't know, can we?
Under section 22.041H, it states that it's an exception of the application of this section, if the child is voluntarily delivered to a designated emergency infant care provider. So I think the indictment is just alleging that she did not do that, so the exception doesn't apply.
Where?
Section 22.041H. It's an exception to the general rule. I believe we can just abandon that because that's not applicable in this case. She did not deliver the child to anyone, so the exception doesn't apply, but I don't think we need to have it in the wording of the indictment to be able to charge her with this offense.
Well, I don't know if that's, I think as I'm reading this, maybe it needs to be in there.
Okay, I don't think it changes
It
what
says
was
it's an
like.
exception. So, but by stating did not deliver, then
The exception doesn't apply.
Section 22.041 applies. I think.
I don't believe it changes.
I don't think it does. Let's just keep it the way it is. I think we'll sort of- So this is a state jail felony, which means if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty and not found guilty. You will be placed on deferred or unadjudicated probation, which can be up to 5 years in length, fined $500. There will be other terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document?
Yes.
Understand it? Discuss it with your attorney? Are the contents all true and correct? Yes. Okay, you have to speak out so she can hear you there.
Oh,
Okay.
okay. Yes.
State's Exhibit 1 is tendered into
No
evidence without objection admitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand what you're charged with. The indictment's been read to you. You've read it. You're guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God. States Exhibit 1, made a part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
Nothing further. I'm going to follow this agreement and find you are mentally competent to enter your guilty plea. It's freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But the court is going to instead defer or postpone any findings of guilt so long as you follow these terms and conditions of probation. Make sure you do. You will be placed on deferred or unadjudicated probation for 5 years. If you fail to follow these properly, your probation could be revoked. You could then be found guilty and a sentence up to the full range of punishment, up to 2 years in the state jail. And that would be a felony conviction. Have you ever had a felony conviction? You don't want one. It closes off a lot of doors of opportunity. Anything else on this? Okay, please see the probation officer.
And Judge, the Canaan case will be dismissed, but paperwork has not been sent over by the state yet.
Sorry.
There's going to be a dismissal on the other case. It just hasn't been sent over by the state
Okay.
yet.
Thank you, Judge.
Thank you. Ricardo Kelly?